Okay, let's go ahead and get started. Hello and welcome to Mayor Brown's Adapting U.S. Practice to Patenting Pharmaceuticals in China webinar. My name is Gary Nath, and I'm a partner in Mayor Brown's Washington, D.C. office and a member of the firm's intellectual property group. Joining me today are our co-presenters, Lu Yang, Jing Zhang, and Scott McMurray, who will be introducing themselves when they speak. Before we begin, we'd like to mention a few housekeeping announcements. For the best audio quality, please make sure your computer speakers or your headset are turned on and the volume is up so you can hear the presentation. If you have any questions that are unanswered during the presentation, I invite you to submit them using the question and answer feature on the bottom of your screen, and we will do our best to follow up with you directly after the webinar has ended. Regarding CLE credit, we will be providing an alphanumeric code during the presentation. In order to receive CLE credit, participants must record this code on the virtual sign-in sheet that was emailed to you with the login instructions for today's program. And so with that said, let's go ahead and get started. Our program today is Adapting U.S. Practice to Patenting Pharmaceuticals in China, and we're going to be discussing some very important developments in China relating to patenting pharmaceuticals and how they compare to U.S. practice. Again, to introduce myself, my name is Gary Nath. I work in our Washington, D.C. office. My practice is intellectual property, and in particular, intellectual property litigation. And our firm, Mayor Brown, is a large international law firm. We have offices around the world, in the United States, Europe, Asia, South America, and the Middle East. Our firm operates in all different areas, all different practice groups, but one of our most important practice groups is intellectual property. And we provide a full range of services relating to IP, including obtaining IP, licensing, transactions involving IP, and enforcing and protecting intellectual property rights. So with that, I would like to turn it over to our first speakers, Lu Yang and Jing Zhang.
我就开始了是吗？我先做个自我介绍吧。我是北京知名律师事务所的卢阳，然后我之前是在专利负责委员会工作，然后主要负责的是医药生物领域的这个专利无效案件的审查工作，另外还有一些是专利审查标准的制定工作，参与过多次专利审查指南，还有专利法的修改工作。那么现在是在北京知名律师事务所，然后主要还是负责这个医药生物领域的这个专利案件的这方面的业务。
Mr. Lu was introducing himself. He worked at the Chinese equivalent to USPTO. He sits on the review board for several pharmaceutical patent hearing invalidity cases for many years. Now he is a partner at the Chinese law firm of Zhang law firm. And while he was at Cycle, he was part of the process of promulgating many revisions to the review guidelines for a pharmaceutical patent. He's also part of the process that amends China's patent law in regards to pharmaceutical patents. After joining private practice with Zhang law firm, he also focuses his practice on applications, prosecution matters related to pharmaceutical patents, as he's very experienced in that field. And just a short introduction about myself. I am Jing Zhang, a partner with Mayor Brown's Government and the Global Trade Group. And I also have substantial patent litigation experience. Today, I will be translating for Mr. Lu's portion of the presentation.
很高兴今天能跟大家介绍一下在中国过去一段时间里面，对于专利审查过程中补充实验数据审查标准的一个变化。
Today, it's my pleasure to present to you the recent changes in Chinese prosecution practice as relates to pharmaceutical patents and supplemental testing data.
在中国的专利实践中，通常认为药品专利申请中记载这个实验数据是为了满足两个法条的需求，一个是专利法第26条第3款，一个是专利法第22条第3款。 那么在中国专利法里面，第26条第3款规定，说明书应当清楚完整的说明，这个发明的内容。那么对于药品专利而言，通常会认为实验数据是清楚完整说明药品发明所必不可少的一部分。如果说明书中缺少了实验数据，那通常会认为它不符合专利法第26条第3款。另外一个涉及到实验数据的条款是专利法第22条第3款，也就是创造性的条款。那么一般来说，对于药品专利，如果说它技术方案跟现有技术中已知的方案相类似的话，会认为它必须要有更优异的效果才具有创造性。这里面需要说明的是，中国专利法可能跟其他国家略有不同的是，在中国的专利审查实践中，通常会认为一旦技术方案具有预料不到技术效果，那么它就具有创造性，这是一个充分条件，而不仅仅是考量因素之一。
So under Chinese practice, the reasons for submitting testing data together with the application for a pharmaceutical patent is primarily to satisfy the requirements of two statutory provisions. The first statutory provision is Article 26.3, which provides that the description, the original specification of a patent application shall set forth the invention or utility model in a manner sufficiently clear and complete so as to allow a proceeder in the relevant field to carry it out. And to satisfy that requirements, Chinese law generally requires that certain testing data be included in the original specification. Otherwise, it is highly likely that the original application will be considered not specific enough to satisfy the sufficiently clear and complete requirement. And the second relevant statutory provision is Article 22.3. So for this provision, a Chinese pharmaceutical patent application also needs to satisfy the inventiveness requirements. That means if the patented technology is similar to a pre-existing technology, some type of prior art, then there's a need to prove special results or surprising results. This is one place where the Chinese rule may be different from US rule. So under Chinese law, the concept of inventiveness or inventive step is similar but not identical to the US concept of obviousness. But unlike the US, as long as the applicant can approve unexpected or surprising results that conclusively proves the patented technology or the technology trying to be patented is non-obvious or inventive per se. So that's a big incentive to prove that the technology trying to be patented is not obvious or through surprising results.
那在实践中，那通常这个药品专利的争议会集中在这个药品的效果方面，所以呢，在专利权人经常会在程序中希望补交一些专利申请文件中所没有记载的实验数据，以此来证明这个发明符合专利法第26条第3款或者是专利法第22条第3款的规定。但是对于这个补充实验数据能不能接受，一直都存在一定的争议，审查标准也发生过多次的变化。
So disputes surrounding pharmaceutical patents usually centers on the effects of the technology trying to be patented. That's why supplemental testing data is very useful in terms of proving up the intended effects of the pharmaceutical trying to be patented. And that's why it's usually a debate during the prosecution process, and also because there's an incentive to submit supplemental testing data during the prosecution process, the examination standards and as relates to whether the supplemental testing data can or cannot be accepted has been changed several times.
下一个题。在2010年的那个专利审查指南里面，它是明确规定，就是说所有的补充实验数据都是不予接受的。而到了2017年，这个标准，这个对补充实验数据的限制有一定的放开。它是明确规定，就是说 对于这个申请日之后补充的实验数据是可以进行审查的。但是对于哪些实验数据能够予以接受，它设定了一个前提的条件，也就是说，只有补充实验数据所证明的技术效果是本领域技术人员能够从专利申请公开内容中得到的，这种情况下才能够予以接受。但对于什么样的情况属于能够从专利申请公开的内容中得到的，存在有2种不同的理解。一种会认为就是说，只要在说明书里面有文字记载，就属于可以从这个公开内容中直接得到的。还有一种理解就是认为，必须是要原始的这个申请文件中已经有数据证明的这一部分数据，才可以再进一步的通过补充实验数据予以补强，或者说通过对比实验数据用来证明它具有一个更好的效果。
As you can see from the slides, there have been changes to the patent examination standards as relates to supplemental testing data. And in the 2010 version of the guidelines for patent examination, generally supplemental data is not allowed. And when it moves up to, when we move forward to 2017, in the 2017 guidelines for patent examination, you can see that the rules were loosened a little bit, and supplemental testing data can be examined, but whether it could be accepted is another matter. The 2017 guidelines set forth a prerequisite for accepting supplemental experimental or testing data. The requirement is that a person skilled in the relevant technical field must be able to obtain the effects that the supplemental data relates to from the original disclosure of the patent application. In practice, there are actually different understandings of what does that requirement mean? What does the requirements of what does the requirements actually requires in terms of a POSITA must be able to detect the technical effects from the original disclosure or specification. One understanding is that as long as there's some written record referencing the effects of the pharmaceutical to be patented, that satisfies the requirement. The other understanding is that it is not. And you have to, for the technical effect to be detected by a POSITA from the original disclosure, the original disclosure must have some experimental data in the specification already. And the supplemental data can only strengthen the existing testing data in the specification or proffer more comparative testing data to further strengthen the arguments regarding the effects of the pharmaceutical to be patented.
这种不同的理解，实际上对于这个专利权人和无效宣告的请求人都造成了一定的困扰。但在2020年的时候，国家知识产权局还有最高人民法院都分别对这个问题进行了一个诚信性的解释。
So the difference in understanding created a lot of challenge for patent owners and challengers of pharmaceutical patents alike. So in 2020, both CIPO, Chinese Intellectual Property Administration, and the Chinese Supreme Court issues rules clarifying this, the Chinese rules and practice on this issue.
下一张 PPT 吧。首先是2020年审查指南进行了修改。一方面呢，它是在这个具体条款里面明确了说，申请人可以通过补交实验数据来克服专利法第22条第3款和专利法第26条第3款的缺陷。
So the first change is that, as you can see from the guidance for patent examination issued in 2020, there are quite a few relevant changes. The first one is that it is specifically added to the guideline that supplemental testing data can be submitted to cure deficiencies related to Article 22.3 and Article 26.3. The first article relates to specificity of the original disclosure. The second one relates to surprising results.
另外，审查指南中还对于什么样的情况可以补充实验数据可以接受，提供了2个具体的事例。
And in addition, the guidelines also provided 2 concrete examples for to show when supplemental testing data should be accepted.
下一张 PPT。在示例一中，那个当说明书中当权利要求保护一种化合物 A 的时候，如果说明书只是记载了这个化合物 A 的制备方法，然后还有确定它有一个降血压的作用，以及测定降血压活性的一个实验方法，但没有记载具体实验数据的时候，这个时候申请人是可以通过补交实验数据来证明它符合专利法第26条第3款的规定。
So let's look at example 1 first. So this example assumes that a compound A is claimed, and the original disclosure in its specification describes the preparation method for compound 1, and also the fact that compound 1 has blood pressure lowering effects, and also specified some experimental methods for measuring that effect, the blood pressure lowering effects. But however, the original disclosure doesn't include any experimental data proving the results of lowering blood pressure effects. And so the example shows that now under the new Chinese practice, the applicant can submit supplemental testing data to prove to further prove the blood pressure lowering effects of compound A in order to satisfy the requirements of Article 26.3.
下场 PPT 吧。然后在第二个示例中，那么当权利要求保护一种通式化合物的时候，那么这个时候如果说明书只是记载了这个通式和它的制备方法以及一些具体化合物的制备实施例，并且记载了它有一个抗肿瘤的作用，以及测定抗肿瘤活性的一些实验方法，但是对于它这个最后的实验结果只有一个泛的描述，比如说是在这个 IC50在10到100纳摩尔之间的时候。那么这个时候，为了证明这个具体化合物具有创造性，申请人是可以通过补交实验数据，比如说补交其中某一个具体化合物 A 的这样的一个实验结果，来证明它与现有技术中对比文件里公开的这个化合物具有一个更好的效果或预料不到的这种效果。
So example 2 relates to a compound of general formula, and it can consist of multiple compounds such as compounds A and B and etc. And assuming the original specification describes the general formula 1 and also its preparation methods, and also documents that it has anti-tumor effects, and also some specific experimental methods for determining the anti-tumor activity. However, in terms of the exact effects of the compounds anti-tumor effects, the original specification only give out a range, which is 10 to 100 nm. And in this example, under the new Chinese practice, you can submit a supplemental comparative experimental data, which shows that compound A within general formula 1 has a IC50 value of only 15 nm, while the new compound trying to be patented, general formula 1, has a IC50 value of 87 nm. So through that, you can so this example proves that you can use supplemental testing data to further specify the intended effects of the pharmaceutical to be patented.
从上面两个示例可以看得出来，现在在中国专利局对于这个补充实验数据持一个更开放的态度，只要基本上原始的说明书里面对这个实验数据有文字描述的话，那么就可以通过补充实验数据来进一步证明它的创造性和这个能够实施。
So as you can see from the previous 2 examples, the Chinese authority has become more open-minded about supplemental testing data. As long as there are some descriptions in the written descriptions in the original specification related to the testing data, then supplemental testing data can be submitted to prove inventiveness and showing that the patentability requirement has been satisfied.
行，下一张 PPT。然后审查指南的这个修改也很快体现到了国家知识产权局所做出的无效决定里面。在这个2021年做出的第47087号无效决定里面，他对于审查指南里面的这个标准做了一个总结性的陈述，也就是说，他认为专利权人应该是可以通过补交实验数据来弥补专利法第26条第3款和专利法第22条第3款的这个缺陷，但前提是本领域技术人员结合说明书的整体内容，能够确信专利权人在申请日前已经关注到了这个技术效果，并且已经对这个技术效果进行了一个研究。
So as you can see from here, the new Chinese practice has also been reflected in invalidation decisions issued by the China National Intellectual Property Administration, which is the new name for CIPO. As you can see from CNIPA invalidation decision number 47087, the invalidity decision from CNIPA specifically says that supplemental testing data can be submitted and accepted to cure effects related to Article 23.2 and 26.3. But there's a prerequisite. The requirements that there must be sufficient disclosure in the original specification that would show to a POSITA that the related technical effects has been noticed by the applicant before the application date. And also there has been some study by the applicant before the patent application is filed. As long as that requirement is satisfied, generally the supplemental testing data is acceptable to cure the previously discussed defects in the original specification.
下面一张。除了国家知识产权局之外，最高人民法院也在2020年出台了一系列关于这个补充实验数据的规定。那么在2020年出的这个司法解释里面，第10条规定就是说，药品专利的申请人在申请日以后提交补充实验数据，主张依赖该实验数据证明专利申请符合专利法第22条第3款和26条第3款规定的，人民法院是应当予以审查的。
So the Chinese Supreme Court also issued a series of decisions in 2020 related to the supplemental testing data issue. And the first one related to a set of rules issued by the Chinese Supreme Court. And the Chinese Supreme Court in Article 10 says that if a pharmaceutical patent applicant submit supplemental testing data after the filing date and claims to rely on the data proof that the patent application complies with Article 22.3 and Article 26.3 of the patent law, then the Chinese court shall examine the supplemental testing data.
那么在2021年，最高人民法院做出的第33号行政判决书里面，也引用了这个2020年的这个司法解释，并且在其中对于为什么应当接受补充实验数据，以及什么情况下应当接受，什么情况下的补充实验数据可以接受，进行了一个详细的说明。
And even though the number listed here is 2019, and the administrative judgment from the Chinese Supreme Court was actually issued this year in 2021, it is the administrative judgment number 33 of Supreme Court. And in this administrative decision, the Chinese Supreme Court clarified the question of why and under what circumstances supplemental testing data should be accepted.
首先，判决中认为，应当审查补充实验数据的原因在于，不同人员对于现有技术的认知和理解不同，申请人很难在说明书申请人在说明书中没有记载特定实验数据的情况是无法避免的，所以说这个时候应当允许申请人去补充实验数据，并且对这些实验数据应当进行审查。但是呢，允许补充实验数据并予以审查，并不意味着所有的数据都会被接受。
the Chinese Supreme Court first explained that it is almost inevitable that different applicants will have different understanding of the current states of art when they file the patent application. So following from that, the examiner should accept and examine the supplemental testing data to level the playing field and allow the applicant an opportunity to curing effects and defects related to specificity and also surprising results. However, just because the examiner should examine the supplemental testing data doesn't mean that the supplemental testing data should also be accepted.
下一张。在这个判决里面列出了2个能够接受补充实验数据的条件。第一个呢是这个技术效果已经在说明书中明确或者隐含的公开了。第二个呢还又强调了一下，就是说不能够通过补充实验数据来弥补原申请里面的一些固有的缺陷。换句话说，这2个条件实际上都是说就是说你所补充实验数据所证明的效果应当是在原申请文件中明确记载的。那么补充实验数据只是说对于这个技术效果的这个真实性进行一个证明，而并不是说通过补充实验数据去增加一个原始申请文件里面完全没有提到的技术效果。
So as set forth in Administrative Judgment number 33 from the Chinese Supreme Court, the acceptance of supplemental testing data must meet 2 conditions. The first one is the technical effects to which the supplemental testing data relate must have already been disclosed in the original specification. And the second requirement is that supplemental testing data cannot be used to cure inherent defects of the original disclosure in the original application. So actually the 2 requirements goes to the same concern. That is the supplemental testing data can only be used to prove the accuracy of certain technical effects already disclosed or explicitly disclosed in the original disclosure. It cannot be used to add a new technical effect, such as a therapeutic effects, to the application that did not already exist in the original disclosure.
下面一张。这是这个案子的具体的一个情况。那么这个案件里面，那个原始的申请文件里面，只是简单的记载了一下化合物具有一个令人惊讶的高代谢稳定性和生物可利用率，但是没有记载任何具体的实验数据。那么一审的法院是认为这种泛泛的记载不足以使本领域技术人员确认发明具有该效果，所以说没有接受专利权人提交的补充实验数据。那么最高法对这一点进行了一个纠正。他认为说，原申请文件中已经记载了这个高代谢稳定性和生物利用度这一效果，只是因为缺乏数据而无法进行一个确认。那么这个时候，专利权人补充实验数据的目的是在于证明这个待证事实的真实性，所以应当予以接受。
So on this slide, I've set forth the underlying facts related to the administrative decision from the Supreme Court we just discussed. So as you can see here, the patent application relates to a compound, and the key part is the effects of the compound to be claimed. And the original disclosure used very general statement that just generally says it has surprisingly high metabolic stability and bioavailability. And the court of first instance found that because the statements of bioavailability, stability is so general, a procedure would not be able to detect the technical effects from the original disclosure. And Supreme Court actually overruled that, saying because of the statements we just discussed, the technical effects of the compound to be detected has already been documented in the original disclosure, such that the supplemental testing data can be accepted to further prove the effects already noted in the original disclosure.
从上面的案例其实可以看得出来，那个国家知识产权局和最高人民法院实际上在补充实验数据的这个审查标准上已经达成了一致。应该说就只要原始申请文件中有文字记载的数据，就可以通过文字记载的效果，就可以通过补充实验数据来进行一个补强性的说明。这一点实际上对于药品专利的这个审查，我觉得影响还是非常大的。基于这样的一个审查标准，很多过去可能被无效掉的，或者说没有办法授权的专利，都会因为后续补交的实验数据而被授予专利权，或者说是维持专利权的有效。
So as you can see from all the previous examples we have discussed, CIPO, the Administrative Patent Authority, and the Chinese Supreme Court are generally in agreement. So right now, with regard to supplemental testing data, the general rule is as long as the technical effects to which it relates has been either explicitly or implicitly disclosed in the original disclosure, supplemental testing data is generally allowed to strengthen the general statements or prove up the general statements already made in the original disclosure. This has wide-ranging implications for pharmaceutical applications and patents in China. So some patents that used to be invalidated or could not be issued based on the old practice, disallowing supplemental testing data may now be changed. A lot of the new patents may be upheld in regards of its validity, or new patents could be issued because now there's more lenient Chinese rules about supplemental testing data.
以上就是我今天要介绍的内容，希望对大家有一定的帮助，谢谢。
So that concludes my comments today regarding the changes and the current new Chinese practice regarding supplemental data. Appreciate your time and attention today.
Okay, thank you very much for that excellent presentation. Our next speaker will be Scott McMurray. Scott, take it away.
Thanks, Gary. Thanks, everyone. Thank you, Mr. Liu, for sharing your insight into the new Chinese practice. So next, I'm going to go through the framework for the U.S. practices for submitting data to the Patent Office, particularly new data, and then maybe address a few items on how they correlate with the Chinese practice currently. Next slide. Jing, I'm seeing a few gray boxes in front of the slides.
Is it better now?
That's fine. So data submitted to the Patent Office can be used for a few different purposes, and it's been accepted for a while. Historically, of course, as Mr. Liu alluded to, it was not accepted in China. The data in the US can support patentability in various ways. Next slide. So experimental data can be used with the Patent Office to overcome rejections. Particularly, they can provide objective evidence of non-obviousness to overcome obviousness rejections. Typically, these would be surprising results and sometimes commercial success for pharmaceutical compounds. They also can provide evidence to overcome some 112 or 101 rejections, and they can prove a lack of enablement for anticipatory art. The benefits of using supplemental data are that they can defer costs for tests or defer a choice of preferred embodiment. For example, a drug candidate that you're not sure which one you will choose to develop. You can file a patent application to protect the compound so that it does not lose patent protection, and then later develop data after you've decided which one you want to pursue. Next slide. There's a few mechanisms for doing this at the Patent Office. The first is to actually have your data in your specification. Of course, this would not be new data generated after the patent filing. That would be something you generally present in declarations under Rule 37 CFR 1.132, or even in attorney remarks and responses to rejections from the Patent Office. It is the applicant's duty to present. The applicant is the one who must present the data and convince the examiner that it shows patentability or meets whatever requirements the examiner has raised in his objections. The examiners are required to consider data as long as it's timely submitted, for example, within the statutory limits for responding to office actions or with extensions of time or RCEs, that type of thing. And MPEP section 716 provides an overview of the USPTO data treatment. Next slide. So there's a few things to be aware of how the USPTO treats data. The examiner can doubt the data, but he must provide proof. He has to give a legitimate reason or evidence, such as scientific literature calling your data into question. Some data the examiners have to accept as accurate unless they have a very good reason to doubt it, and that would be data that appears in the specification or in a 132 declaration. And that's because both of these documents are sworn to be true and accurate by the inventors or the declarants. Data submitted, though, in attorney remarks can be disregarded as attorney argument without much of a reason. The examiner is required to give a reason if you press him, but it doesn't always. However, usually, in my experience, I found that the examiners do consider, often favorably consider data that's just in attorney remarks, but it's best practice to have a declarant attesting to the data so that there's no question that the examiner can reject it as simply attorney remarks. Next slide. So the data you submitted has to be of certain quality. So one, it has to be accurate. It can't be misleading or can't be misleadingly presented, and it needs to be complete. And the reason for this is that if you fail to do so, you can violate your duty of candor and good faith before the Patent Office. And if it's material, then that could render the whole patent unenforceable even after it issues. This also includes withholding results that are inconsistent with the data you present to the Patent Office. That's a big flag for inequitable conduct. And one of the problems with inequitable conduct is that they can infect continuing applications. So if you have a continuation or a divisional or something like even a CIP, where the same data was relied on by the examiner to allow it, that's something that could cause problems for later patent application if there was a material inaccuracy with the data for continuations and divisionals in addition to the underlying patent. Next slide. So the USPTO can be skeptical of your data, but they have to give a reason. And the data submitted can overcome the examiner's reasoned doubts. In certain circumstances, they're difficult to overcome these doubts, and that'll be things where there's historically incredible assertions like you've invented cold fusion, you've invented perpetual motion, or often in our space, you've invented a way to prevent or cure a disease like cancer or HIV. There actually was recently allowed a PrEP, P-R-E-P, HIV treatment patent that was allowed after the US HHS had submitted clinical data. Historically, of course, clinical data is not required for patentability, but because the claims were to preventing HIV, the examiner relied on the clinical data showing that it actually did work as a preventative. Next slide. There are some limits to submitting data for post-filing data. Similar to the requirements in China, it does need to confirm assertions that are in the specification as filed. Typically, these would be assertions of non-obviousness or utility and enablement to a lesser extent. But generally, you cannot cure a lack of a written description with supplemental data, with new data. It's often generally because it would be considered to be new matter. It looks like China's a little bit more lenient now, but they do still have a requirement for some disclosure in the initial application that you can use as a hook for your new data. Also, for experimental results to overcome a prima facie case of obviousness, they need to be significant, particularly if there's a strong showing of prima facie obviousness. This is a little bit different than China, where it sounds like now you can have surprising results that would lead to a finding of non-obviousness per se. That's not the case in the US. Strong cases of obviousness cannot be overcome even by surprising results or commercial success, that kind of stuff. Next slide. Another limit on US data submission is that the data has to have a nexus with the claimed invention, and particularly the invention's novel points. So there's a few cases that have addressed this recently. Essentially, a nexus is where the data is reasonably commensurate with the scope of the claims. And the nexus has to exist with the merits of the invention, i.e. the patentable aspects of it. If the nexus is something that is in the prior art, it by definition does not go to the merits of the invention and cannot support patentability. So to get around these limits, we find that it's safest to claim the effect that the supplemental data shows. However, that's going to be a balancing act with how much you want to limit your claims, because obviously any additional limitations in your claims will further narrow them. So you need to decide if the strength of claiming the effect shown by the supplemental data is worth the potential narrowing of your claims from capturing infringement for others. A rich source of data for pharmaceuticals would be clinical trials. And we are finding that the USPTO and the US courts are increasingly scrutinizing nexus for data that's submitted. Next slide. So some issues with submission of data, particularly new data, that crop up in later patent litigations are that, one, the data locks you into a position. It's something that you really can't move off of without risking an inequitable conduct filing. The other issue is that it does flag or could flag potential enablement issues. For example, if the data was relied on to show how your invention works or that it does work, that could be something that will be a point of attack later in the litigation on the patent. Another issue is that data submitted is almost always the focus of attacks in patent litigation. So you need to make sure that it is buttoned up, accurate, and complete, and that there's nothing inconsistent in your own files. And of course, the reasons for these are that material inaccuracies in data presented to the patent office risk inequitable conduct, even if they were not appreciated as inaccurate during prosecution. We do find that the discovery process in US patent litigation can often uncover inconsistencies in the data, and that's something that is almost always brought up by a patent challenger. Another issue is that if you do rely on a declarant, a 132 declarant, or even an inventor declaration, the declarant may later refuse to cooperate or be hostile. That's particularly if he leaves the company under bad circumstances and no longer is willing to help you. That's a little bit mitigated in the US by the current doctrine of assigner estoppel, where an assigner of a patent is impeded from arguing the patent is invalid. However, that does seem to be a bit in question. There's a case on certiorari at the US Supreme Court, Manover Cervical v. Hologic, that is considering this question. But in general, it's best to keep on good terms with your declarants in case you need them later. And of course, you can mitigate US data submission concerns by, one, avoiding using supplemental data, overcome rejections by attorney argument or by claim amendments, or relying on data that's in the original specification. Next, you want to, even if you do submit data, you want to ensure that it is 100% accurate, it's complete, and it's not misleadingly presented. There's no inconsistent data in the client's or the testee's files, and that you haven't presented it in a way that could be argued as misleading the examiner to it. And again, these all risk inequitable conduct in rendering the whole patent unenforceable if there is a failure of that and it is material. The other way to mitigate is by just stick to the facts. Describe what the invention or what the data shows, but try not to interpret it. Let the examiner draw his own conclusions as to why the data shows the invention is patentable or overcomes his rejections. Often it's best to have the declarant simply present the data as well so that he can't be accused of misinterpreting the data, again, risking inequitable conduct. Next slide. So there's a few things that we've learned in the US, and I think that they should help prosecute patents in China under this new data standard. There is not a one-to-one correlation, since this is a fairly new requirement, it remains to be seen how it will be implemented in terms of the details and how it will be considered. One of the differences, of course, is the Chinese specificity requirement, which kind of overlaps with written description and enablement and isn't quite coextensive. And of course, as in the US, supplemental data in China can now, as Mr. Liu said, provide surprising results that will show inventiveness and can prove a statement of effect that the examiner might find isn't adequately supported by data. You can submit the data later as long as you had a basis for that assertion in the original disclosure. There are some limits that we understand to the new Chinese practice. One is that, as I mentioned before, supplemental testing data can only support effects that are described in the original specification, and they can't actually add a new therapeutic effect, as Mr. Liu's example showed. You need to have something that's already disclosed in an effect that's already disclosed in the specification in order to be able to use data to support a claim to that That kind of wraps up an overview of the U.S. practices and how they might apply to China under the new China rubric. So I want to thank everybody for listening, and I think we might have some closing remarks from Mr. Zhang, and then we can take some questions.
Yes, thank you very much, Scott. I was fascinated to hear the kind of the similarities, but also the important differences between the practice in China and the United States. Let me add a few comments of my own based on what I've heard today. First of all, patent protection is critical for pharmaceutical companies, as I think our attendees know. Companies often spend millions of dollars developing new inventions, new pharmaceutical products, and the ability to protect those technologies through patents is absolutely critical. And companies are seeking these days worldwide protection for their pharmaceutical inventions in the United States, China, and elsewhere. But obviously, the US and China are extremely important markets. So I think understanding the laws and how they can be protected is very important for pharmaceutical companies. The next observation is that the developments in China recent are very, very important. They strengthen the ability to obtain pharmaceutical patents, and that's a very positive development. At the same time, the situation is evolving, both in China and the US, but especially in China with new regulations and new rules. It's very important to understand what the current state of the law is, what the developments are, and how those can be used to the advantage of a pharmaceutical company trying to obtain patent protection in China. And while the standards in China seem to be moving towards the United States, there's still very, very important differences that companies need to consider. And those are rapidly changing. So the next observation is that any company that wants to patent their pharmaceutical inventions in China and the US really need to understand the lay of the land. They need to understand the similarities and the differences between both. They need to consider what to put in a patent application, what not, what opportunities they have to supplement later on, and what the limitations of that might be. And it's very important to assemble a very well-qualified team of attorneys, both in the United States and China, and to think strategically at the beginning of the process what the systems are and what the opportunities and the limitations are, and have the attorneys work together to figure out what to disclose and when, and what the impact of that will be on protecting a pharmaceutical invention, because the ability to do so and the timing of disclosures and the ability to submit supplemental information can make the difference between getting a patent and not getting a patent, or being able to enforce a patent in court, or not being able to enforce a patent in court. So I think this is all very important for pharmaceutical companies to understand, and to understand the implications of these differences. So I think we do have a few minutes. Jing, do you have questions for the panelists?
I think it's a very interesting discussion, but I would defer to Scott. Scott, after hearing Mr. Lu's presentation, do you have any questions regarding the Chinese practice?
Thanks, Jing. Yes, I do. I don't want to step on anyone else's of our attendees' toes if they do have questions. So feel free to jump in. Anyone else, if you do have a question, you can put it in the chat box, the Q&A box, and we will get it. But in the meantime, Mr. Lu, I was wondering if you could kind of explain the difference in an implicit disclosure that could be supported by supplemental data and a direct disclosure, if there's any examples that you could provide the panelists, provide the attendees.
卢先生，那个 Scott 想问一下啊，那个我们最高法院的那个行政决定里边说，这个就是说它的这种技术效果可以这个直接透露，也可以这个间接透露。那么你有没有这个就是说具体的这个例子可以这个解释一下，什么叫这个直接透露，什么叫这个 implicitly disclose， 也就是说间接的这个透露？
因为那个最高院的那个判例也是今年刚出的，所以这个可能还有待于那个最高法那边去对这个进一步的解释。但在这个在这个案件里面，实际上它并没有一个虽然说它里面有提到说它要提高这个叫高代谢率和稳定性，但实际上就是说它只是在背景技术部分提到了。我觉得其实上这也是在最高院的这个判决里面，他说既可以是直接的记载，也可以是隐含的记载的这样的一个原因。但具体是说什么样叫隐含的记载，这个可能需要法院那边最后给一个明确的这个就是案例来支持。
So that's a very good question. So probably the answer will have to wait for the Chinese Supreme Court to issue a more on point decision to clarify exactly where the line should be drawn between explicit disclosure and implicit disclosure. But one thing to note is that in this specific example, the statement about high bioavailability is made in the original, it's in the prior art portion of the original application, but it is comparing the technology sought to be patented with the prior art. And the court of first instance makes some reference to that. The statements is made in the prior art version, but actually Supreme Court actually considered that as adequate disclosure of the technical effects to which the supplemental data relates, and actually think the data should be examined and accepted as acceptable evidence. And I think that's Mr. Lu thinks that sheds some light on what implicit disclosure means.
另外我觉得就是说，其实，在那个国家知识产权局的那个无效决定里面，它那个标准，我觉得可能会是未来比较多参照的一个标准。也就是说，根据说明书的记载，能够确信当时申请人已经关注到这个效果，而且做过一定的实验。我觉得这个可能是未来接受这个实验数据的一个主要的一个判断的依据。
So Mr. Hu thinks in practice, the standard articulated by cycle, now CNIPA, may become the prevailing standards in determining whether supplemental testing data acceptable or not. And the standard again is that the original specification disclosure should be read as a whole. And the question is, when read as a whole, whether a procedure will be able to detect that the applicant at the time of filing has noticed the technical effects and must have done some experiments to study the effects. As long as that's satisfied the notice and you can determine some studies must have been done, then generally a supplemental testing data should be acceptable.
Thank you very much. I think that was a quite fulsome answer to my question, and we'll look forward to seeing how the Chinese courts interpret these. That's pretty much everything I have for me. Any questions from Gary or Jing or the audience?
Scott, I have a question for you. So given the, what do you see as the key differences between China practice and the US practice in terms of submitting supplemental information? And how does one reconcile the two as they're seeking worldwide patent protection, both in the United States and China?
So to answer your second question first, I think that it actually makes it easier to have a unified worldwide strategy for patent protection. Historically, before the change in the Chinese practice, for example, with a pharmaceutical compound, you'd be limited to claiming the compounds that you've actually made and showed data for that they work. Now with this, I think you can maybe expand your repertoire a bit, similar consistent with what you do in the US, where you can get maybe slightly broader chemical space coverage around your compounds through genus claims by submitting additional data later. I think it does remain to be seen to the extent, what extent that will be allowed in China, but I think the door is open for having a more unified strategy with similar to what you can do in the US and Europe. In terms of the first question, with the most significant differences, I think, as Mr. Liu said, one of the biggest ones is that, and even more so than the practice in the US, the submission of surprising results can overcome obviousness or inventiveness in China. That's something that a strong case in the US couldn't be overcome even by surprising results, though generally they do help very much for compounds. I think with the per se inventiveness of surprising results in China, it will greatly help the patenting of compounds, particularly ones that are at all similar to ones known in the prior art. I think it also helps to be able to supplement your disclosures with data that can support a claim to an effect, or maybe to more specific type of effect than you had in your original disclosure, which could be even broader than the protection that you're allowed in the US. So I think this is definitely a strong move for protecting inventions in China, and it could yield stronger patents and broader protection for pharmaceuticals there.
Okay, excellent. And let me just wrap up with the same question to Mr. Liu. Mr. Liu, what do you see as some of the key differences between the practices in the United States and China? And what does this mean for companies that are seeking to protect their pharmaceutical inventions in both countries?
卢先生 ，Gary 就想问一下，当您听完今天的这个我们的这个宣讲，您觉得就是说中国和美国的这个实践的重要区别在哪里？然后这个就是说，如果一个公司希望在中国和美国都申请这个药品专利您对这些公司有哪些的这个建议？
其实我觉得就是说这次那个包括审查指南的修改，还有包括最高院出的司法解释，我觉得两个国家的那个整个的标准实际上在趋同，也就是说对于补充实验数据的接受程度，中国现在应该说是整个的应该是放开了，跟美国更加接近了我是觉得但是那个因为也是2021年刚开始实施这个标准。所以我觉得很多可能具体什么样的补充实验数据能够接受，其实我觉得美国那边的经验可能未来会对中国这边会有一个比较大的帮助吧。了解美国的经验可能会对中国这边的就是哪些补充实验数据能够接受会有一个比较大的帮助。因为就是刚刚这个案例里面，虽然最后最高院是接受了这个补充实验数据，但是也是考虑到这个补充实验数据最后并没有能够证明这个发明具有预料不到具有效果，就是说它对比的对象存在一定的问题，所以也没有最后是支持这个专利的这个就是没有维持这个专利还是把这个专利无效掉了。所以我觉得刚刚其实听那个咱们这边介绍美国对于一些这个什么样的数据能够接受，我觉得可能未来我觉得两国的标准可能会越来越趋同。
Mr. Liu thinks that there's no doubt that China is moving more towards the US prevailing practice, being more lenient about supplemental testing data. However, the Chinese practice is very new. It's only started to be implemented in 2021, so there's a lot of open questions. For example, in the Supreme Court example, even though the test data was both examined and accepted, ultimately it was found insufficient to prove its surprising results because it was a comparative analysis testing data, and the other side of the comparison was found improper and unprobative. So that's why ultimately it wasn't able to achieve the goal it was tendered for, which is to prove inventiveness. So Mr. Liu thinks the body of practice already developed in the US is much more developed and should be a valuable resource for companies wanting to patent their new pharmaceuticals both in China and the US, and may be able to sort of get a better results under the developing Chinese rules.
Excellent. Thank you very much, Mr. Liu, and thank you, Scott, and thank you, Jing, and thanks to all our panelists. I think that's all the time we have today. And with this, we will conclude today's webinar. It's been our great pleasure to have a chance to talk to you today. We hope the information that we shared was useful, and we thank you so much for your participation. Have a great day, everybody, and thank you again for joining us.